Should felons be able to own guns? Yes. The answer is absolutely yes, unequivocally yes, no stipulations, yes. And if you are an American and you believe in the principles of freedom and justice, then that is the exact position that you should hold as well. And that's what we're going to be covering in today's video, why that is, as well as a case that seeks to go to the Supreme Court to challenge the prohibition on firearms ownership by individuals that have a bit of a checkered past. But really quick, we do have to keep the lights on. So here's a quick word from today's sponsor. I have a really hard time getting behind products that declare themselves to be gray man products, as in trying to make the end user blend in more, particularly those survival bags that are covered in webbing. Well, I think Mission First Tactical actually did it this time around. The Acro is their spin on a high-quality bag with concealed carry and armor considerations in a package that looks modern rather than the typical stuff that we get in a tactical bag. And that's really the whole point. We want that bag to say, that dude is hauling a picnic of avocado and kale sandwiches with a side of oat milk, not an MP5 SD and 3 extra mags. Mission First offers VSO viewers a hefty discount with my code that you can find over at the affiliates page, and I want to say thank you very much to them for making today's video possible. If you would like a full synopsis of the Acro line, then never fear, I have exactly the video for you. I'll have it listed in the description box down below. So first up, let's talk about like the general background information that you really need to know to understand this case. And what I would say first is that there is absolutely a path in many states for felons to have their firearms rights restored. In fact, I would say that my attorney, or I guess since he's not currently working for me, I would say that the attorney that I call first when I need one, that's primarily what he does, is restore people's firearms rights that have had them stripped. This absolutely does happen every day, and anybody who insinuates that that is not the case is being disingenuous at best and probably nefarious if you really track down their motives. But that said, in addition to the fact that this is kind of already a thing, this has only been going on since 1968. So from 1776 to 1968, if you were a criminal or known to commit criminal acts, after you served your time, you were restored to full functionality, right? This has only been a thing since 1968. We should also consider for a second the validity of case law from 1968. Think of all the evils that have been perpetrated by big government around or about that time, and consider whether that is the type of mindset that we want to perpetuate in today's society. It sounds like a pretty dumb idea to me. In fact, I would say that we should probably just throw out the entire era. But who knows? Maybe your mileage might vary. Principle, broad speak, so to speak. We'll say that there is an act that we identify as a crime, and you have been adjudicated guilty of that offense. That crime and the subsequent guilty verdict carries with it a bracket size punishment. It's from this amount of punishment to this amount of punishment, depending on the discretion of the judge, right? Let's say that you get sentenced to a month in jail. Okay, you go to jail, you do the time, you get out, and then what happens? Well, the way that our legal system works today is you continue to carry that punishment basically for the rest of your life, which is not the way that it was supposed to work. And I would say that if we're intellectually honest about how things work today, is the current legal system and penalty system, the incarceration system in the United States, fosters recidivism. So it, for all intents and purposes, forces people who have made a mistake or, whatever. I'm not trying to be soft on hardcore crime or anything. What I'm saying is you make mistakes sometimes. You do illegal things, some of which shouldn't be illegal to begin with. But that's another discussion for another day. You make a mistake, and then for the rest of your life, you are labeled that because your criminal record follows you everywhere. And on top of that, we have determined that if you just meet the statutory minimums for a particular class of crime, it doesn't have to be violent or anything like that, then you can no longer vote. You can't have your right to defend yourself, et cetera, right? To me, that sounds like a system that is a self-feedback loop. It is designed to keep people in the system. And I don't think that that is the way that our founders envisioned our system of government working. Again, your mileage may vary. Let's head to Utah. We're headed to the 10th Circuit Court of Appeals. This is Vincent V. Garland. I spoke earlier about there being a pathway for particularly nonviolent felons to have their firearms rights restored. I don't know that Ms. Vincent has gone down that path, but I do know that she has decided to go full America and sue the Attorney General of the United States. Congratulations, ma'am. We applaud you. That said, this case is a little bit different from the last case that we talked about that is headed to the Supreme Court. Let me make a distinction there. The Rahimi case, which is the one that we covered last, dealing with felon and possession laws, is at the Supreme Court. This one seeks to appeal to the Supreme Court. So there's a distinction there. They have not been granted cert or anything like that. So I wanted to make that entirely clear. This one seeks to go there. Now, the thing about the Rahimi case is that, for all intents and purposes, Mr. Rahimi is a piece of shit. This woman is not. She is a convicted felon, but listen to what she had her firearms rights prohibited for, as in her right to defend herself, $498.12, a bad check. So less than $500. There are some states where you don't even get arrested if it's under $600 or $900. And this woman has had her firearms rights, her right to defend herself, stolen from her by the government because she made a mistake, count it, 15 years ago when she was self-admittedly a meth addict. Some people end up in a bad way, and they make bad decisions. Since then, she has turned her life around. She has earned 2 post-secondary degrees, including a master's degree, and she runs a nonprofit and is a mother of 2. Can you counsel a person who is the spitting image of did it the right way afterwards, right? And this woman continues to be punished, so she is seeking to go to the Supreme Court to have her firearms rights restored. She's had a squeak clean record ever since, and her contention is that the Bruin decision says that this kind of treatment is inconsistent with the text, history, and tradition of the United States, and damn it, she is right. I would be very interested to see whether the Supreme Court accepts this one. I would like to see them actually take both cases because while some on quote-unquote our side of the aisle are a little bit leery about the Rahimi case, I think that that would be a fantastic test because even though Mr. Rahimi is most certainly a violent offender, the text, history, and tradition of the United States doesn't support the removal of people's firearms rights, even if they were violent. So I would like to see them blow a big hole in that. And I think that what is going to happen with this, I think, is likely they've accepted the Rahimi case. We know that one's going, and they're going to hear that one. Depending on how the decision is written in that one, I think we will hear from this one. If they say, hey, it's in the United States' best interest to keep violent people from gaining access to firearms. If somebody's on the street, then by extension, they have been deemed not a danger to society or reformed. So they should have full capabilities as a productive member of society. If they are not, then they should be in jail. Period. Tangent, sorry. If the Supreme Court does the interest balancing thing and they say, yeah, it's in the best interest of the United States that felons don't have access to firearms or violent felons don't have access to firearms, then I think that it will be pretty much required for them to accept another case that deals with nonviolent felons because there's absolutely no excuse that this woman should have no right to defend herself and be able to enjoy a full functional life with her family and all the things associated with it, simply because she made a mistake 15 years ago when she was under the influence of, more than most likely under the influence of some illicit substances that she shouldn't have been messing with anyway. But again, people make mistakes. And I think that it is clearly demonstrated that at this juncture, this is a good one. She turned her life around. Why is she continuing to suffer? And why is her family continuing to suffer? Because this is a generational problem. It's not just an individual. And that's how our system has chosen to punish people who make mistakes. I don't think that that is okay. And I think that a lot of people out there will agree. And I would like to hear from you in the comment section down below. Go ahead and blast me. Let me know that I'm wrong, that people should be able to have their rights removed for the smallest offense that the government deems meets the threshold. Thanks for watching. We'll see you in another video here at the BSO Gun Channel. Happy New Year.